Very quickly go through what is remaining from yesterday, and which is about parliamentary privilege. You have the Kolkata case, which happened in relation to the Tamil Nadu Assembly, where there was a challenge by the editor of a magazine to the order of the Tamil Nadu Assembly, which sentenced 2 weeks imprisonment for breach of privilege. That's because there was an article criticizing the behavior of the entire Assembly, and it was held that the Assembly's order should not be overturned. In other words, here there was
full screen, sir.
Okay, and here there was therefore an affirmation of the order of the Assembly. In other words, that there was a legitimate reason why the Assembly could have served a notice of contempt of breach of parliamentary privilege. It is rare, but it happens. Now, incidentally, I think it's fair to say, generally speaking, and you can correct me if I'm wrong, that the Tamil Nadu Assembly is particularly notorious for breach of privilege cases. I think if you had a league table, Tamil Nadu Assembly would probably come at the top. Maharashtra also has had a few cases. I don't know what the record of Bengal is, but in Tamil Nadu, journalists have been harassed quite a bit by the speaker, by successive speakers. Now you also have the Hindu case, which also is from Tamil Nadu, where the editor was sentenced, editor along with 5 journalists were sentenced to 2 weeks imprisonment for breach of privilege. And what was the complaint? There was an editorial in the Hindu which criticized the intolerance of the Jayalalitha government. And the actual sentence is, or the actual passage is there. But then, because there was a huge furor about this, the Assembly withdrew all proceedings, and the newspaper withdrew its case. The newspaper was, of course, gone to court. So sometimes, it's a case of the speaker trying to bully the media. Balasubramanian case, I'm going to deal with that. Again, Tamil Nadu. Then you come to Maharashtra, Navshakti, where there was a report in a newspaper which said that in the secretariat to the Assembly, there was a rate card for admission of questions, motions, etc. Basically, the allegation was that corruption was going on, that if you wanted something to be admitted, you pay a certain sum of money. And that resulted in an order for contempt. So really what you're talking about is, suppose you discover in your Assembly there is corruption, and you write about it. Now, very likely, the people who are going to be scrutinized for that corruption are not going to take it kindly, and they will try to slap a charge of breach of parliamentary privilege against you. In most of those cases, the charge will not be sustainable, and therefore you can challenge it in a court of law, which is what happened here. And just to save face, the Chief Minister announced that he was magnanimously withdrawing the case that had been filed against the journalist. Really what it is a defeat for the people who tried to bully the press. Illustrated Weekly, again Tamil Nadu, the article was about the fast gaining notoriety of the Tamil Nadu Assembly in terms of all kinds of undesirable behavior, and this of course also went to the Supreme Court. The order was stayed, and the Assembly backed down. Just see, most of the cases the Assembly has backed down, mainly because the journalists had the courage to go to the court, and journalists supported by their employers. Very, very important to remember, not journalists on their own. So that is the most telling thing about these cases.
So would you kindly, sir, elucidate the relation between the court and the House, that means the Assembly or Parliament, whatever it is, in case of a particular person charged with contempt of Parliament or Assembly for that matter, and how far he can get a remedy in the court of law?
Okay, generally speaking, there is a law which says, there's a rule which says that each of these bodies will not interfere with the other. In other words, the court will not question what happens inside the Assembly, and the Assembly will not, generally speaking, say anything against the courts. This is a rule, it's actually a convention which has been very strongly upheld and followed in India as much as it is in England. Now, there are limits to that rule, because if you say there will be total non-interference, then there can be injustice caused. So what has happened, particularly in countries like India, where you have a written constitution and you have a very strong Bill of Rights, that is chapter on fundamental rights, freedom of expression, etc., the courts have been willing to look at some cases involving alleged breach of parliamentary privilege, and in appropriate cases order that what the assembly has said is not sustainable. Now, this is a very delicate area of the law where you cannot predict with accuracy what the result of a particular case will be. But by and large, if the action of the assembly is outrageous in relation to the media, the judge will definitely come to the aid of the media and say sorry, but such harsh action cannot be tolerated. Yeah.
In all practicality, what we see here is that suppose the court in any of such cases, court wants some materials like the proceedings of the house, or wants to have somebody, either an official or the speaker, or for that matter anybody, as a witness or something. They are denied by the speaker that you should not go to the court. Let the court issue summons and let's see how far the court can go.
It is entirely understandable, but at the end of the day, I would venture to suggest that any such defiance will end with the court winning, not the assembly. That is actually what happened in Keshav Singh's case, if you remember. Keshav Singh was the high watermark of that kind of behavior, where the assembly not only defied the order of the court, but charged the judges with breach of parliamentary privilege. 28 judges of the entire High Court, and yet they did not win. So, if that happens, if it goes to the last stage, I would venture to suggest that the court's order will prevail, not the order of the assembly.
At present, there are three major cases of West Bengal Assembly before the High Court, and all of them are related with the speaker's ruling on certain issues. And one major case was against a prominent advocate, Mr. Onabo Ghosh. The speaker lodged a complaint in his jurisdiction that the defamation case actually, contempt, breach of privilege, and Kolkata High Court ruled out that issue. So there are some examples that when the court's order are being
absolutely. So it's an area which you need to treat with a degree of caution.
Sir, this parliamentary privilege also gives the parliament the right to prohibit publication of something. So
No. Not if what is published is a fair and accurate report of what happens in Parliament.
That's what I'm saying. So when this contradiction comes, I'll give you an example from a smaller scale. The mayor of Calcutta is accused in a bribery case. So the chairperson of the Calcutta Municipal Corporation monthly meeting where all councillors meet, that person enjoys powers equivalent to that of a
Assembly
speaker. So the left front, Congress, BJP, the opposition together protested this thing and they carried placards, shouted. So after it was telecast on live TV and press also published the photograph next day, the chairperson issued a guideline or an order that no one can take any picture, neither shoot anything inside the
chamber.
Yeah. But then what was reported was completely fair and true.
Yes.
So whether a journalist has any right to challenge this order or to not listen to this order?
Now this is slightly tricky because the point you made in the beginning that the council chamber is like the assembly is not legally correct because the concept of parliamentary privilege only applies to legislative assemblies and parliament, not to local bodies. But in most countries, there are similar laws protecting journalists reporting on council meetings. Now, I don't know whether there is such a law in West Bengal. If there is, you are protected by that law, right? So, it is not exactly parliamentary privilege that will protect you. But turning to the other part of what you said about taking pictures, the chairman of the council will be, in most cases, justified in putting those kinds of restrictions. That is not a problem. But not reporting what's happening inside. Most of the time, the reporting is protected by another statute of the state assembly. That you'll have to check. I don't know. Okay. Right. So you can see the general trend is that when these cases are taken to court, usually the assembly backs down. There's a case involving again another Maharashtra case involving Nikhil Wagle, who is a prominent journalist in Bombay. He wrote an editorial criticizing the Maharashtra Assembly for eulogizing a Shiv Sena MP who was basically seen to be a thug. And the Assembly charged the editor of this journal called Mahanagar for breach of privilege. Quite frankly, this would be very borderline and very debatable, because at the most, Mr. Chavan could have filed a defamation case. This is not a breach of privilege case. It's a bit like the difference between contempt and defamation. Anyway, they did that, and Mr. Wagle refused to apologize, and he spent a day in jail, but he continued to be defiant. So sometimes you pay a price for these kinds of action. And then there is another case which is probably from Bengal, I'm not sure, where an MLA published material that had not been allowed to be used in a speech in the Legislative Assembly. And here it was held that the report was not protected by privilege and therefore liable to legal action for defamation, as if it were an unprotected document. So sometimes somebody brings a speech to the Assembly, their speech is not allowed to be read out. And in those circumstances, can a journalist use the speech as if it was made in the Assembly? The answer is no. Only those speeches which are actually delivered on the floor of the House can be used. So that completes our look at that particular topic. Now let's move on to the topic of today, which is, as I said, on copyright. And this is one of the most substantial topics. And quite frankly, this is also a topic which I would say is extremely important for the media. To start with, copyright, of course, is part of what is called intellectual property. In other words, copyright should be looked at as property, except that it is not real property, it's not tangible property, but it is intellectual property, property of the mind, which deserves as much protection as real property. And it's of course relevant to journalists. It's relevant to journalists in two ways. One is, you as journalists produce a lot of creative works, that is to say, your reports, your articles, etc. They are protected by copyright. Other people cannot violate your copyright in your writings or your television programs. Equally, copyright also affects journalists in the opposite way. You, in the course of your work, often use material from other people's works, and you then might be accused of breaching their copyright. So it is a double-edged sword as far as journalists are concerned. And for both reasons, you should be as familiar with the principles of copyright as you can be. The good news in terms of practical application is that copyright law is based on statute law. That is to say, law passed by Parliament. Quite easy to access the law. There's only one act to be looked at in case of doubt. And of course, the other great beauty of copyright law is that there is international recognition. There is mutual recognition across boundaries. So if you publish something in India, the copyright in that publication will be respected or should be respected even outside India, without you doing anything. You don't have to go and apply to another body in the country where you want protection. It is automatically protected as a result of something called the Berne Convention, to which most countries are party. There are, of course, serious problems in countries like India, and the problems are not connected with the law. The law is very good. The problems are connected with enforcement. There's a huge problem of enforcement in a country like India. And I referred 2 or 3 days ago to the fact that the Spycatcher book was published in India, very soon after it was published in Australia, and you could get copies of that book for 10 rupees on the pavements of Bombay. Why? Because they were all pirated copies. So copyright piracy is rampant in India. India is not the only country where it is rampant. This also applies incidentally to Thailand, where you will discover many counterfeit copies being published without any hesitation. So enforcement is a problem. The law is wonderful, but the enforcement is not. And that, of course, is a matter of some concern worldwide. Now, what are the basic points about copyright? If you want to talk about copyright in a sentence, it is the exclusive right of a person to exploit his or her own work. Exclusive right. So, if you produce a work that is copyrightable, then you will have the exclusive right to decide how that work is going to be exploited. Which means, if you want to publish it, you can publish it. If you want to make it into a movie, you can make it into a movie. Nobody else can copy what you've done without your permission. That is all what copyright is about. And it's based on the recognition of your skill, of your labor, and of your investment of time. Why is copyright given protection? It's given protection because the law believes in rewarding people for their skills, for their labor, for their time. Therefore, copyright applies only to works that involve a degree of skill and labor, and of course investment of time. It's available for literary works, artistic works, musical works, dramatic works, etc., including computer software. And copyright, very importantly, does not protect ideas or information, but only the form in which they are conveyed. I want to spend a minute or two on this very important point, because it's sometimes misunderstood. What is protected by copyright is the form in which an idea is expressed, not the idea itself. And this means that two people can get the same idea and still enjoy copyright in their respective works. How is that? It is because the form in which a person expresses an idea is copyrightable. So, a simple example would be, you know that
making film
no. A simple example would be like this. You know that in India, one of the most commonly accessed story comes from a historical work like the Ramayana. It is something that is very popular. And you also know that there are so many movies made, so many television serials made on the theme of the Ramayana. Now, the idea is common to all of them. The story of the Ramayana is common to all of them. But what is not common is the manner in which that story is narrated or put out in each of those movies. And therefore, each version of the Ramayana that is telecast or shown in a movie house enjoys copyright protection separately from the others. So each producer of those movies will have copyright to their own works. Of course, there will be some commonalities, but that's all right. The idea is that you enjoy copyright in relation to the expression of your of a theme or of an idea. So keep that in mind. Very, very important. And of course, copyright strikes a balance between allowing authors to profit from their work and society deriving the benefit of the work. So copyright does actually have a very good objective to fulfill. So what are those objectives? First of all, it protects the creators of artistic and literary works from being unfairly denied the fruits of their labor. If you are the creator of an artistic work, you do not want to be deprived of the fruits of your labor. You have an expectation to derive benefit. Now, there is sometimes a little bit of lack of appreciation of this position. Why? I'll give you an example. A lot of the time, students think that copyright protection for books is too onerous, is too harsh. Why don't we go and simply photocopy a book, which will cost us about 1/10 of the price of the book if we were to buy the book. What's wrong with that? Now, in very practical terms, that is an understandable sentiment. But if everybody started doing that, just imagine what will happen to the author of a book. He will have no incentive to write a book because there is widespread piracy. His royalties will come down to such an extent that he will not feel like writing anything in the future. So copyright does actually work on the basis of incentives, and therefore it is very necessary for the fruits of anybody's labor to be protected. Copyright also gives an incentive for authors to create new works and aids cultural progress. Overall, it helps in advancing the cultural heritage of a particular country. National prestige is also increased by the protection that is given by copyright. Now, there are some practical functions that copyright performs. It ensures that remuneration due to an author is shared equitably among the ultimate consumers. How does this work? Suppose there is a book which is priced at 1,000 rupees. Now, out of that 1,000 rupees, only a very small amount goes to the author by way of royalty. But if the book is read by many people, bought by many people and read by many people, then each person who buys the book contributes a small amount, which together becomes a substantial amount for the author of the book. So that's how the system works. Of course, if you want to take an extreme example of this, you would look at works by people like Stephen Hawking. You know, his book did actually sell in millions, and therefore he was able to profit enormously from the book. But each buyer of the book only has to spend a small amount. So even though you, when you buy a book, contribute a small amount to the author does profit depending on the sales of the book. And it also provides a simple solution to the problem of remunerating authors across national boundaries. Automatically, there are these collecting societies which ensure that remuneration that is gathered is distributed to the respective authors. It also helps to strike a balance between the legitimate needs of society to access material of importance and the equally legitimate right of creators of such material to remuneration. So it benefits not only the authors, but it also benefits society. Now, what are the types of works covered by copyright? I've already given you an idea earlier. Literary works, which includes books, newspapers, newspaper articles, poetry, etc. Incidentally, to qualify as a literary work, the work does not have to have any literary merit. A point worth noting, because you may think that something that is effectively very mundane does not enjoy copyright. Actually, it does. I'll give you a simple example. A railway timetable. Nobody would argue that a railway timetable enjoys literary merit, but a railway timetable does enjoy copyright. Why? Because it is organized in a certain way. The expression in a railway timetable is protected by copyright. Or a football fixture, all those things are protected by copyright. So you don't have the literary merit. And another way of putting it is by saying the works of Shakespeare enjoy copyright in the same way as the works of Harold Robbins. Now, I'm not making any judgment here, I'm just saying there are many people who believe that there is a difference in literary merit between Shakespeare and Harold Robbins, and yet both works enjoy copyright. In fact, it's possible that Harold Robbins has made more money than Shakespeare ever could. But that's the kind of thing that I want to highlight. So literary merit is not a criterion for enjoyment of copyright.
So, is Shakespeare's works still copyrighted?
No, no.
Like Tagore's?
Correct.
50 years, the copyright lawyers?
I'll talk about that in literally a couple of minutes. Yeah. So literary merit is not necessary. Of course, dramatic works enjoy copyright. Musical works certainly. Now, in the case of musical works, you need to be careful, particularly when you're talking about musical works from movies, because if you take a typical Hindi movie song, it consists of many parts, but essentially there is a lyric, there is a music. There is also a tune, there is a composition, etc., etc. Now, if you want to make it simple, the lyrics enjoy separate copyright as a literary work, and the music enjoys copyright as a musical work. So there are two separate elements involved there. And of course, your artistic works, which basically paintings, sculptures, etc., etc. Some recordings, film, broadcast or cable programs, they have separate copyright. So there are quite a few elements involved in copyright. Now, in terms of the legal provision, I already told you it's covered by statute law, and the law involved is the Copyright Act of 1957. It's actually a very good law. It is a law which was passed shortly after independence in India, and yet it serves its functions extremely well even today. It imposes both civil and criminal liability. Another very important point to remember. What it means is, in the case of copyright, if you are guilty of violation of copyright, you can be prosecuted for that, but there can also be a civil action taken against you for liability for breach of copyright. In other words, somebody can sue you for damages in relation to copyright violation, just as they can prosecute you or have you prosecuted for violation of copyright, for breach of copyright. So it's got both civil and criminal liability in the same statute, not separate statutes. Okay? Now, I've already told you about this, that the protection only extends to the expression of an idea, not the idea itself, and there cannot therefore be copyright in historical facts which form the basis of more than one film or book. Now, the important thing about copyright is only available for original works. So originality is important. So the author must have devoted skill and labor in creating the work. Where two artists paint pictures of the same landscape, each is entitled to copyright in his work separately. This can create some problems. I'll give you an example. You know that a monument like the Taj Mahal is often the subject of many paintings. So what happens if a painter positions himself in a certain spot from which he can get a very good view of the Taj Mahal? He paints the Taj Mahal, he moves out, another painter comes, at the same spot he starts painting the Taj Mahal. Very likely their two pictures will be similar, and yet each of them enjoys copyright in his own work. This is not the ideal example, but what I'm trying to tell you is that even when there is so much similarity, there can be separate copyright enjoyed. Usually, of course, there will be some differences. So don't be under the impression that it is not possible for someone in that position to enjoy copyright on their own. They can. And when there's a fear that a work being produced may appear similar to another work, it's a good idea to keep drafting notes in case a dispute arises later. This is very important even for journalists. Suppose you're writing a story and you want to protect your copyright, or you're writing a film script. This happens a lot of the time. Then it is a good idea to keep your drafting notes, because that will give you an indication, or that will give the court an indication, should a dispute arise, that the work that was being challenged was an original work, because somebody else may also write something similar, and simply because there are similarities, there may be a dispute. And in those circumstances, if you keep drafting notes, your case will be strengthened to that extent. And the crucial test is whether in the eyes of a reasonable third party, the works in question appear similar or distinct. Reasonable third party. Again, we go back to the concept of reasonable, the reasonable person. And minor similarities will be disregarded when deciding copyright disputes. And of course, very important, mere slogans and catchphrases do not enjoy copyright. There are many slogans that are used, for example, in advertising. Those slogans do not enjoy copyright. But of course, some of the producers of those slogans use other forms of intellectual property, such as trademark, to get protection for their works. But copyright, they will not be able to get. Okay, term of copyright, it is the lifetime of the author plus 60 years.
Sorry, sir. So, in some ads or some brand,
Yeah.
there are certain slogans associated
Yes.
with a particular brand.
Yes.
And we have to understand that those slogans are not copyrighted.
No. No.
I can
Unless
use it for something else.
yes, unless they have been trademarked or
Right.
in any other way protected.
There will be an R with a circle or something like that.
Yeah. Yes.
Sir, what about using the title of a book as a headline in newspaper?
Not a problem generally. Now there is a separate system for registration of titles. Disputes normally arise when you have movies with the same title. You know that there must have been a film produced 40 years ago, and there's a new film produced with the same name. I can't immediately remember names, but I know that in Hindi films this exists. Devdas. Okay. Now there'll be many, not many. There'll be 2 or 3 movies with the same title. The way it works is that is regulated by the IMPPA, Indian Motion Pictures Producers Association. They have a system of registration of titles. So if you're going to produce a movie, you can register your title, and that title will be reserved for you for a certain period. I honestly can't remember what it is, but I think it is 30 years, something like that. During which time somebody else cannot use the same title. But after the period is over, then the title can be used. So, to answer your question briefly, if you're using the title of a book in an article as a headline, that's fine. There's no violation of
So why
copyright.
this Copyright Act is not being applicable in case of examination?
Sorry?
Why this Copyright Act is not being applicable in case of examination?
How do you mean? Give me an example.
Openly a copy from one.
Okay.
Frequently. So why? That's my simple question.
Why is crime so rampant in India?
There is a particular act to deal with this.
There is a particular act to deal with crime in India called the Penal Code.
Yes, but
And why is
that's
crime
what
still
I'm telling you.
why is crime still prevalent? I don't have an answer. That is all I can tell you by way of an answer. Okay. If you ask me a question, why do people cheat? That's an answer for a psychologist to answer. A question for a psychologist to answer, not for me. Okay. So no.
We can't write a definition for a particular thing.
Anyway, we'll leave that there for the time being. Okay. So the point I was making was about slogans and catchphrases. Okay. Term of copyright, very important. The term of copyright protection is the lifetime of the author plus 60 years. The lifetime of the author plus 60 years. So, if you produce a work when you're very young, your work will enjoy copyright, and you die late, then your work will enjoy copyright for a long time. But if you finish a work one day before you die, then your work will only enjoy copyright for 60 years plus the remainder of your life up to the 31st of December of that particular year. Now, you mentioned 50 years. That has been superseded, and that has been superseded as it happens coincidentally because of something that happened in Bengal.
Because
Exactly. You know that the estate of Tagore, Tagore's works, as you know, were very profitable. They sold in large numbers. They made a lot of profit for Shantiniketan. Now, the heirs and successors of Tagore requested the Indian government, when copyright is about to expire at the end of 50 years, that the government should consider their request favorably and extend the copyright by 10 years, so that they will enjoy 10 more years of profits from the work. The government graciously accepted that request. And I'm told that at the end of those 10 years, the estate of Tagore made another request that can you please extend it by another 10 years. At which point, I believe that the government said, no, you're becoming greedy, sorry, we will have to draw a line there. And so they restricted it to 60 years. Incidentally, 60 years has now become the norm globally. So in a sense, Indian Copyright Act would have been slightly out of sync if it had been 50 years. So 60 years is now normal, although there are some countries with variations, but by and large 60 is accepted. But remember, it's 60 years plus the lifetime of the author, not just 60 years. Very important for that to be remembered. And in the case of photographs, cinematograph films, etc., it is a fixed term of 60 years. Not 60 years plus the lifetime of the author, just a fixed term of 60 years. And in the case of anonymous works, 60 years from the beginning of the calendar year in which the work was first published. So there are quite a few distinct rules about the term of copyright. Now, who owns copyright? Of course, it's the author, and author means, in relation to a literary or dramatic work, the writer, the person who wrote the work. In relation to a musical work, the composer, not the conductor, which in Western music can become a point of contention. In relation to an artistic work, the artist. In relation to photograph, the person taking the photograph. In relation to cinematograph film, the owner of the film at the time of its completion, which is most of the time the producer. And in relation to gramophone record, the owner of the original plate from which the record is made at the time of making of the plate, and that applies also to CDs. And where two or more authors create the work, they can own copyright jointly, and they can agree among themselves what is the proportion in which they own copyright. So 60-40, 50-50, whatever. And when a ghostwriter is employed to write a book, he owns the copyright unless there's an agreement to the contrary. This has created huge disputes because you know that there are many celebrities who want to publish their, let's say, their autobiographies. And however talented they are in their own fields, they may not necessarily be very talented in writing a book. So what do? They get a professional writer to write the book. And they want glory, so their name appears as the author of the book. And in very small print, there will be somewhere a line saying, in assistance with or in collaboration with the name of the ghostwriter, who actually would have written the entire book. But this is how it is. Now, in those circumstances, who owns copyright in the book? The law says that it's a person who wrote the book, skill and labor. That is the ghostwriter, not the celebrity. Even though the celebrity's name appears in the book. But this can be changed because the law of copyright is quite flexible. So the law of copyright allows for this presumption to be displaced through a contract. So if the celebrity says to the ghostwriter, look, I'm going to be the owner of copyright even though you have written the book, but you know what I'll do? To compensate you for your work, I'm going to pay you a lump sum. So I'll pay you 10 lakhs or whatever. You forget your copyright. From now on, I'm going to be the copyright owner. And if that is clearly done and done without any legal impediments, then the celebrity owns copyright, not the ghostwriter.
Sir, in some books we see that the C mark is there with the author, and some books it is with the publisher. So it is made clear that who has got the copyright.
Correct. That's
how did the particular person get is not my lookout.
That is because there is a contract between the parties. And you're right, you don't have to worry about how that happened. What you're worried about is who is the copyright owner. So if you have to seek permission, then you will have to go to the person named there, whoever it is. And you don't have to worry why their name appeared.
And it goes to the descendants also, like sons and the inheritance also, the copyright?
Well, obviously yes, because if the person dies, then remember there's 60 more years and it will go to the successors of the particular parties.
So would you be deliberating on neighboring rights in your presentation?
To the extent possible I will, okay? But I'm very conscious of the lack of time today, so I'll just have to be strategic in the way I deal with
Like
it.
now mentioned on neighboring
There is
rights.
a fair, I can talk to you privately about this
Sure.
later on. There are a number of things to be done. So do remember this ghostwriter thing, very, very important in practical terms. It is a rule that can be displaced by contract. As I said, the author is normally the first owner of copyright, but there can be changes. Now this is also very important. Where a journalist is employed by a newspaper and he writes for the paper, then copyright normally rests with the proprietor of the paper. Normally. This also can be displaced. If you have an agreement with the proprietor, when you join service, if your contract states very clearly that you will retain copyright in everything you write for the newspaper, and if the employer agrees, very important, the employer is to agree. You can't just impose this term on the employer. If the employer agrees, then copyright will be with you. Normally, it's very difficult to expect the employer to agree because the bargaining power between an employee and an employer is not balanced. The employer obviously has a higher bargaining power, but if you are such an important writer then and the employer wants your services, he may agree to it. An example would be, you may remember that the Times of India employed R.K. Lakshman as their cartoonist. Now, normally, if you apply this rule, copyright in all the cartoons produced by Lakshman for the Times of India would vest with the Times of India. But no, because Lakshman was such a distinguished man, such an accomplished man, he was able to negotiate with the Times of India to retain copyright in his works so that he would be able to exploit the works as he wanted to exploit them. That is why subsequently you find a number of books published by R.K. Lakshman which are reproductions of cartoons that originally appeared in the Times of India. But he could do it on his own because he held the copyright. So this is a rule that can be displaced.
So otherwise in general, what is the duration of copyright on any material published in a newspaper?
Same as what I told you earlier. 60 years plus the lifetime of the author.
But generally newspaper articles are quoted and reproduced and nobody has gone to the court.
If you ask me a question, why is law disobeyed in India, I have no answer, honestly. That happens a lot of the time. I'm very sorry, I know I'm disappointing you, but I just don't have an answer. I'll give you an example. At the moment, I'm working on a book for a friend of mine whose father, who died recently, has written a lot in the Indian press. This is a very distinguished lawyer. And the son asked me, can you please try to put this book together? I said happily, because I knew the father very well. And what I'm now doing is I'm writing individually to the people in each of those newspapers for permission to reproduce the article written by him in their paper. Strictly speaking, I don't have to. But that is not the way. First of all, there is the law, but there is also ethics. So I want every article to be cleared with every newspaper which originally published it. So now somebody can tell me, well, you're being very foolish. Do what other Indians do and just go ahead and publish. It is just that I take a different view. So I don't know. I mean, the strict answer to your question is the laws of copyright apply as much to newspaper articles as they do to books.
So 60 years from the date of publication?
No. 60 years from the date of the death of the author.
Suppose it's by staff reporter or somebody.
Yeah, then it will go to the proprietor of the newspaper, 60 years plus the lifetime of the proprietor of the newspaper.
No, the proprietor is the company.
No, well,
Like Bennett Coleman, in case of
yes,
Pennsylvania.
well, not always. It could sometimes be an individual, but okay, it can be a company. In which case, it will be just 60 years from the date of publication. Absolutely, yeah. Okay, sometimes it can be an individual employer. Sometimes, in which case, it will be lifetime of the employer plus 60 years.
Okay. So one thing.
Yeah.
This happens especially in case of science writing.
Yeah.
Suppose research paper that has been published.
Yeah.
So while writing a piece on a broader topic, something from the paper is quoted. The journalist mentions this person wrote the paper, even mentions the name of the paper, everything. But is it necessary to seek permission from that person?
No, for reasons which I'll tell you in 3 or 4 minutes. Okay, so I'm just taking this step by step. So that is the rule. But if you're a freelance writer and you send an article to a newspaper, then normally you enjoy copyright, not the newspaper, not the proprietor of the newspaper. Freelance. Even that can be displaced, because it may be that there's an agreement between the freelance and the newspaper under which the newspaper retains the right to republish the article, etc. So this rule is one which is subject to change by negotiation. Where a person is employed by another to take a photograph or paint portrait for remuneration, then copyright the photograph or portrait vests in the employer in the absence of an agreement to the contrary. So if you were to say, for reasons of vanity or otherwise, please paint a picture of me, then normally in the absence of an agreement, you will retain copyright, even though the normal rule is that the painter has copyright what he paints. But if it is done in those circumstances, then clearly there will be a difference. Where someone undertakes to do creative work for the government, copyright works vest in the government unless otherwise agreed. This is another exception to the rule. Okay, is it possible to transfer copyright? The short answer is yes. So anyone owning copyright can transfer it to others, and this process is called assignment. So if you write a book and you have copyright in the book, you can assign your copyright to someone else, either for money, in other words for remuneration, or out of love and affection. So you might say, I want to assign my copyright to my brother or my sister. Now all that is entirely acceptable. When a person owning copyright dies, it passes on to an estate like any other property, which is what we have discussed. And assignment should be in writing, very important, not oral assignments. And the owner of copyright can also issue licenses to other parties, either generally or for a limited use. So you can sometimes say when you've written a book that I am willing to let you reproduce 2 or 3 chapters from the book, but for a limited time, or only 2 or 3 chapters, not the entire book. So you can assign according to your own wishes. I just need to point out, if you assign copyright to someone, then the term of copyright does not change. So that you can't have a situation where a person who has written a book assigns copyright just before he dies to a very young person. Then copyright doesn't extend for the lifetime of that young person plus 60 years. It only extends to the normal duration, that is the lifetime of the original author plus 60 years. That's a point which needs to be remembered. License can sometimes be implied. So if you, as a writer of a letter to an editor, sends the letter to the editor of the newspaper, you are actually giving an implied license to the newspaper to publish your letter. And then you cannot complain that the letter was published without your permission, because when you submit a letter to an author, to an editor, the intention is that it will be published. And when the author of an Indian work, only Indian works, unreasonably refuses to give another person a license, then the other person can make a case to the copyright board, who can, in certain circumstances, issue a compulsory license. This is very rare, but Indian law does have this provision, which some people have criticized. What it does is, if, for example, you want to reproduce someone's work, a typical example would be, somebody has published a book, and you want to, let's say they published a book in English, and you want to publish a Bengali version of the book, because the book is very attractive, very popular, and you ask permission from the owner of copyright for permission to publish a Bengali version of the book. Obviously, you would be willing to pay money. This is not free. But the author says, no, under no circumstances am I going to allow you to publish a Bengali version. Now, you then have a right, under Indian law, to go to the Copyright Board, which is a government agency, and apply for a compulsory license. Now, what will then happen is, theoretically, the Copyright Board will give you a license to publish the book in Bengali as long as you agree to pay a fee that is determined by the Copyright Board, and the fee will be then given to the owner of copyright. Now, many people consider this to be harsh, because what if somebody genuinely does not want his work to be exploited in that way? He does not want the money, he does not want the work to be published in that way. Why should you compare? But for public policy reasons, the Indian government or Indian Parliament has chosen to include such a provision in the Copyright Act, but that only applies to Indian works. So you cannot say, I like a work published. And there's also a provision for appeal against decisions involving compulsory licenses. So the author who has been aggrieved over the issue of a compulsory license can appeal against that decision, which is only fair, because it's possible that the Copyright Board has unreasonably awarded a compulsory license. And in the case of embargoed material, any publication prior to the embargo will constitute infringement. This is very important. Now, you know, as journalists, you sometimes get press releases which say that there is some information, very important information, but at the bottom of the press release or the top of it, it will say, not for publication before 12 noon on a certain date, or whatever time. Now, if you publish the contents of the press release before that date and time, you're breaching copyright law, because you are not given permission to reproduce anything from the press release until the embargoed time and date. Therefore, you have to be very careful when you deal with embargoed material. You can be sued for breach of copyright, and that is a risk that journalists sometimes face. Now, relinquishment of copyright. Is it possible for a person to give up copyright? The short answer is yes. An author can give up all his rights in a copyrighted work by giving notice to the registrar of copyright. You may think a person is mad to do this, particularly when he derives benefit. But there are some people who are altruistic, who may say, I don't want any more profits from my work, so I am relinquishing my copyright, in which case the work becomes open for reproduction by anybody. There's no need then to seek permission for reproducing such works. Now, there is something called the Copyright Office, which is an office that maintains a record of titles registered in the Copyright Act. You don't have to register your work for qualifying for copyright, but if you want, you can. And authors can register their titles, but registration is not compulsory. And there's a Copyright Board, which consists of 3 to 14 members appointed by the government, including the chairman, etc., etc. And they sometimes are called upon to determine disputes. Now, what is the standard to be used to judge or to assess infringement of copyright? Generally speaking, copyright will be deemed to be infringed when anyone without a license from the copyright owner does anything which the owner alone can do. I mean, in very simple terms, infringement means unauthorized copy. That is what it is in most cases. It's also an offense to knowingly permit use of any premises for profit for a performance involving infringement of copyright. Suppose you are the owner of a hall and you allow a dramatic performance to be conducted in your hall, knowing that the dramatic performance is a violation of copyright, then you would be just as liable as a person breaching copyright. And substantial copying will be enough for the purposes of infringement, not 100%, but substantial. And what is substantial will be judged on a case-by-case basis. There is no formula. It doesn't say 80% or 90% or anything like that. It will be decided by the facts of each case. And in the case of cartoons, the drawings carry the copyright, not the jokes. Very important. If any of you is a cartoonist, then remember, it is the drawings that carry copyright, not the jokes. The same joke can be said in a different way. And so it goes to the principle of copyright covering expression of an idea, not the idea itself. Now, even when the owner of copyright authorizes the making of copies, but only for personal use, it will be an infringement. The copies are distributed to third parties. A simple example would be, if I supply copies of my slides to you at the end of the course, I am supplying it on the assumption that it will be used by you and you alone, not for further distribution. So if any of you is enterprising enough and says, you know what, I can make a quick buck, I'll put together these slides and start selling them as notes on media law, then that would be an infringement of copyright. Sorry. And anyone who authorizes the copying or publication of copyrighted material without permission is also liable for infringement. For example, supplying photocopies of copyrighted work with articles for publication. And anyone who is involved in the onward transmission, importation, etc., are also liable for secondary infringement. This is like defamation. Not only the person who is defaming, but also anybody who distributes, who is involved in publication. They will also be liable. And the intention of the infringer is not relevant, but may become relevant in relation to the reliefs sought. Again, a little like defamation. You cannot say, if you're accused of, or if you're sued for breach of copyright, you cannot say, oh, but I never intended to breach copyright. That is not a defense. But of course, if you do it unintentionally, then the amount of damages awarded will be less than if you did it intentionally. And acknowledgement of sources do help, but only up to a point. This is an issue which arises from time to time. Suppose you were to reproduce something from another person's work, and then you acknowledge the source. Is that going to absolve you of liability? The short answer is no, but the longer answer is it may help. At least the possibility of huge damages awarded against you would be reduced if you acknowledge the source. So that is again a good principle to use. On the question of liability for secondary infringement, you have the example recently of a bookseller, not a bookseller, a photocopier in Delhi University. This chap was supplying photocopies on a large scale to students. I think they called it study packs. So he would take chapters from various textbooks with gay abandon and photocopy the entire chapters, put them in a plastic cover and sell to students. This became a serious case in the Delhi High Court because obviously the publishers were extremely unhappy over this arrangement. It was large-scale copying. There is no other way to describe it. And yet, the Delhi High Court ruled in favor of the photocopier and against the publishers. It's a matter which has agitated a lot of publishers, and quite frankly, foreign publishers are beginning to lose faith in the Indian market, because if this sort of thing is allowed to go on, then there are serious issues to be considered. Will foreign publications be published in India? This is a matter which in the future will become a live issue. But of course, the argument on the other side is, look, he's only doing it for the benefit of students, and students cannot afford to buy these books, which are very expensive, etc., etc. It is difficult to tell how this whole debate is going to play out in the future. But the current position is that the man who is photocopying it has been vindicated by the courts. Yeah.
So what was the court's rationale for this?
The court's rationale, such as it is that it falls within the exception which I'm going to talk about for private study, etc. And also that the balance to be struck between protection of property rights, which is what copyright is all about, and freedom of expression, and freedom of expression actually in some respects, which includes right to education, etc., etc., public policy grounds. The balance has to be struck, in this case, in favor of allowing publication, as long as certain safeguards are met. And the photocopier, in his arguments to his lawyers, said that I'm doing it on a very limited scale. I'm not selling it to anybody. I'm selling it only to Delhi University students who come for approved courses and come through their respective lecturers or tutors or whatever. In other words, this is all strictly controlled. That's the rationale that's been used. I would urge you to read the judgment. It is interesting because for those of you who like to know more about copyright or intellectual property, this is a good judgment. I think it can be critiqued both ways, the verdict of the court. Okay, anything else at this stage? If not, let's move on. What are the principles for determining the infringement of copyright? That there can be no copyright in an idea, subject matter, etc., which I've already told you. So, cases would therefore be confined to plagiarism of the form, manner, arrangement, and expression of an idea. Plagiarism means copying without permission. Where the same idea is being developed in a different manner, similarities are bound to occur. In such a case, the court should determine whether the similarities are fundamental or substantial aspects of the mode of expression developed in the copyright work. And if that is not the case, then there is no infringement. So remember the phrase is substantial or fundamental. That's the basis on which a court would decide whether there has been infringement. The court should also ask if the reader, viewer, or listener, having read, seen, or heard both works, gets a clear impression that the subsequent work appears to be a copy of the original. So again, what the court says is, we are going to adopt the standard of the reasonable person. If the reasonable person thinks that one is a copy of the other, then there is infringement. If not, there isn't. Ultimately, of course, that task falls on the judge as a reasonable person. And since a violation of copyright amounts to an act of piracy, it must be proved by clear and cogent evidence. So the person who is alleging plagiarism must prove plagiarism through cogent evidence. Now, what are the defenses against copyright infringement? There are quite a few defenses. It's not as if simply because you've been made liable that you'll be required to pay damages. So, the first defense is fair dealing, sometimes called fair use. What it means is that anybody is allowed to use reasonable quantities of extracts from copyrighted works for a number of purposes. First of all, for criticism or review. So suppose you're writing a review of a book. It is inevitable that you will take passages out of that book in your review. And that will be allowed without permission. But of course, do remember the crucial word, reasonable. In the name of reviews, you can't reproduce huge chunks of the original work. So, reasonable quantities. Also reporting current events. That goes to your question. Research or private study. Suppose I give you notes. You can use those notes for private study without my permission because it is allowed by the law. Public readings or recitals. You know that sometimes there will be, I'll give you a simple example. In relation to the murder of the journalist 2 days ago. Now, if there was a candlelit vigil at which some readings of the journalist's works were performed, you don't need to take permission from the journalist's estate for those readings, even though you're reading copyrighted works. So that's also exempted. But there's another very important condition in all this. The source must be acknowledged where the material is published and excessive or disproportionate use will negative the defense. So going back to your question of reproducing something from a television channel, current affairs, no problems as long as it is a reasonable quantity, CNN or ITV or whatever, and the quantity has to be reasonable. And I'll give you one or two cases about what is reasonable and what is not. So as long as those two conditions are complied with, then generally speaking there is no infringement. Now, as I said, you will have to acknowledge the source, but where the material is used fairly, the courts will allow the defense. Now, this particular case, Time Warner and Channel 4 TV, involved a movie called A Clockwork Orange, which at the time was banned in Britain but allowed to be shown in France. So, excerpts were taken from France. Excerpts of the movie were taken and shown by Channel 4 TV, which is one of Britain's TV stations. And Time Warner, who held the copyright in the movie, sued Channel 4. And Channel 4 argued that what they showed were short extracts, I think for a total of no more than 3 minutes or something in a program lasting half an hour. And it was held that that was not an infringement. BBC and British satellite broadcasting is about sports. Now in sports it's like this. It's very difficult to predict the exact amount of time for which you are allowed to reproduce extracts. But let's say you're covering a football match, which typically would be 90 minutes. Now obviously the portions that you will be showing will be the key parts of the match. In other words, the goals or the missed goals. Now if you show the extracts lasting say about 10 seconds or 12 seconds, which is what on average these excerpts will be for, then you will be okay, as long as you provide acknowledgement. But there is no specific time limit that can be put. Now I'll ask you a question. Is it possible for an extract which is 9 seconds long to be shown in the news about a sporting event? Is it possible for that to be considered excessive?
Yes, if it's splinter.
If it's a?
Splinters, 100 meters.
Exactly. Usain Bolt, if you remember, 9 seconds. There you are. That means you're showing the whole of it. So it depends on the context. Yeah.
So there is no standardization like we get told that it's 40 seconds.
No.
Nothing.
No. Well,
But reasonable, what is the...
that's the point. You see, reasonable depends on many factors, including how long was the original event. So suppose you're taking a cricket match, which runs for, if you take a test match, it will run for 5 days or whatever. Whereas if you take a football match, which is only for 90 minutes, in proportion to the totality, if you use excerpts that are of a certain duration, then the court will have regard to whether that duration is reasonable or not. That's why it's impossible to put a figure on what is reasonable. Now it is possible that your industry may have had some sort of internal arrangement saying 40 seconds is acceptable. I'm not aware of that, but that may be the case. And of course, given that litigation in India takes ages, people will normally not worry about suing because it will be forgotten very soon. And all that will happen is you pay lawyers a few lakh of rupees for a case that will be heard for 22 years. It's not worth it.
I think BCCI doesn't allow, showing images of the IPL cricket matches by the news television.
At all. At all. I'll be very surprised.
So
Only
it
for
depends
IPL.
on who has got the copyright of a particular match.
True. Even then, I would imagine, now I'm subject to correction, that very short excerpts will still be possible because you can record it from somewhere else and then show it with acknowledgement and very small quantity. You're right, generally speaking they won't allow because they pay so many lakh crores.
In case of news items, how long, in case of television news items, how long is the period of copyright? I think it's 1 calendar year.
No.
Sometimes they produce that scene that particular year.
Yes, that is to determine the starting point of the copyright period. So normally in news and current affairs, you would use it contemporaneously. You wouldn't. It is stale news if you used a clip which was old. But on the other hand, there is a value for old clips, archival clips. So what happened during the Munich Olympics is still sometimes shown, and it is copyrighted. So you cannot ignore it completely. So you will have to have regard to the law of copyright.
What is the duration of the copyright?
60 years from the time of first publication. Okay, right. Now, a strict approach is taken in relation to use of unlicensed photographs. Remember, funnily enough, photographs are often the subject of great litigation. You know why? Because some pictures are very expensive to obtain, particularly the ones supplied by the world's great picture agencies. And if you have a picture taken by one of the really big photographers, they sell for sometimes thousands of pounds. And in those circumstances, if you use a picture just like that, you will very likely be infringing copyright. Now I know that a lot of people say, you know what, I found this picture on the internet and I'm going to use it as part of my article. Simply because something is put on the internet does not make it copyright free. Do remember, you still have to take permission. Don't simply go to Google Images and say I want a picture of this, that or the other. It is there, I'm going to use it. Of course, in many cases, people may not be sued because they don't know it's been used or that they think it's not worth the bother, particularly foreigners who, if they have any sense of how the Indian legal system works, will say, better to forget it than to come and get stuck into the Indian legal system and be bogged down for so many decades. But the legal position is that simply because something is freely available on the internet does not mean it is copyright free. You still have to respect copyright for material that is on the internet.
Whose permission is to be sought?
The permission of the owner of copyright. You may have to find that out. It requires a little bit of detective work, but that's the price you pay. There is something called fair dealing, which is also a good defense that can be used in relation to copyright or use of copyrighted material. So, it is possible to use materials for research or private study fair dealing. Again, not in unreasonable quantities. Extracts from books placed for criticism or review, reports of judicial proceedings, certified copies of documents supplied legally. Now, reports of judicial proceedings and certified copies of official documents can be used in their entirety. There is no percentage or anything. Because you can't say I'm going to use only one part of a birth certificate or a death certificate. That can be used entirely. Use of lecture notes by pupils for instructional work, also permissible. Reproduction of matter published in the official gazette. Very boring stuff, but you can use it without any hesitation. Don't worry about copyright. Incidental inclusion is another very useful defense for media people. That is where you use copyrighted work in a casual, subordinate way or by way of mere background. And that will not be an infringement of copyright. I'll give you a simple example. Suppose there's a movie, a feature film, and in the feature film, there is a scene in which the hero is sitting in a car and he's waiting for his girlfriend to come out of her home. Now, while he's sitting in the car, the producer puts on music from another movie, a popular song from another movie, as if that song is being played in the car of the hero who is sitting waiting for his girlfriend. Now, technically it's a violation of copyright because you are including someone else's work without permission. But if it is incidental, and again if it is for a short period, you don't play the entire song, then that would be excused under this defense. Public interest is a possible defense. It's not expressly recognized in the Act, but most people would agree that a court will take this into account in certain circumstances. So, if you have a leaked document, suppose you're a journalist and somebody gives you a document which you're not supposed to have, the government will either try to prosecute you under the Official Secrets Act, or the government might try to sue you for breach of copyright. Because remember, there will be copyright owned by the government in that leaked document. Now, you could argue, if you are hauled up in a civil case, that you published it in the public interest. And I would suggest that a sensible judge, having regard to the facts of the case, might accept that defense. And of course, also it's an important aspect of copyright law that copyright would normally not be enforced when the material is immoral, scandalous, or contrary to family life, injurious to public life, public health, or safety, or the administration of justice, or likely to incite or encourage others to act against any of the above interests. So if you try to argue that you have copyright in a pornographic video and somebody has reproduced excerpts from the pornographic video, very likely your claim will be rejected because in the first place, what you have is illegal. Assuming that what you have is illegal, in other words, by the standards of obscenity, etc. So you cannot enforce copyright on something that is immoral, scandalous, or contrary to family life. The courts will also refuse to enforce copyright in relation to works that are shockingly immoral, blasphemous, etc. Now, you can use material from public records without worrying about infringement of copyright. So, public documents, for example, public records office, National Archives, etc. Also, no infringement of copyright in relation to reports, proceedings of statutory inquiries. So, commission of inquiry, you don't need to take permission. Moral rights are also rights that are like copyright, but they're not exactly copyright. Let's go ahead.
But the commission of inquiry reports, there are two types. One is placed in the house, that means parliament or assembly.
Yes.
Then it becomes public.
Correct.
And another kind of commission report that it is submitted to the government.
Correct.
And the government has
No,
not done anything.
they will, of course, there the copyright will be enforced strictly. Yeah. Okay, moral rights are like copyright, but slightly different. So what you have is, in respect of certain works, the following special rights on the part of the author, or to be enjoyed by the author. The right to be identified as the author, which impliedly includes the right not to be falsely described as the author. So what it means is, if somebody agrees to publish your article and they do not include your name as the author, then you have a moral right to insist on the name being included. But equally also, if somebody publishes an article of yours with someone else's name instead of your name, then that also can become an issue under moral rights. The right not to suffer any distortion, mutilation, or other modification to work. Now this becomes relevant when you submit an article to a newspaper for publication. You're a freelance, you submit an article, you know that normally a newspaper reserves the right to edit the article before publication. They don't guarantee that your article will be published exactly as you submitted, for a variety of reasons. But if the editorial process involves a distortion of your work or a mutilation of your work, now what that is will depend on the facts of each case, then you might be able to plead infringement of your moral rights. And also the right not to suffer any other action in relation to work which would be prejudicial to the person's honor or reputation. And in terms of the duration, moral rights last for as long as copyright work lasts. All of them except the right to identify the author can be assigned or inherited under Indian law. So that is just, by the way, it doesn't feature as frequently as copyright cases. Copyright titles, normally book or newspaper titles should not qualify for copyright protection, and passing off can sometimes apply. So there's in law something called passing off, which can be used, and much stronger protection is offered by registration as a trademark. So that's a possibility as well. What are the remedies for infringement of copyright? You can seek an injunction. Suppose somebody was about to reproduce something on which you own copyright, and you come to know about it before they publish. They have not taken your permission. You can go and try to get an injunction against the work being published. Search and seizure, it is possible for premises to be searched and materials to be seized when there is infringement. An example would be, you know that in India there is widespread piracy of CDs. In the old days, video piracy used to be a very common phenomenon, but now that videos are not very much in use, CDs are pirated on a large scale. So suppose you are the owner of musical works in a movie, or even a movie itself, and you know that somebody has made multiple copies of CDs or DVDs, and they are selling it. If you know where these CDs or the DVDs are stored, you can have the police go and raid the premises to have the place searched and all infringing copies to be seized. It is something which is a very useful remedy as long as you know where the material is stored. That's important. And remember, you have to do it with the help of the police. You can't yourself go and seize any material. Damages, you can get damages for any profits which have been lost or license fees that could have been properly charged. You can get accounts for profits in relation to any excess profit made by the defendant. You can get delivery of copies where you know that the defendant has come forward and you say, whatever copies are remaining, please return them to me, please give them to me. And there are criminal law remedies. It's possible in an extreme case for a person to be imprisoned for between 6 months and 3 years and a fine of between 50,000 and 200,000 plus the seizure of infringing copies. That's the criminal law side of copyright, not the civil law side where you claim damages. And in some countries, for symbolic reasons, the government also makes it a point to have public exhibitions of destruction of copyrighted materials. So in Thailand, for example, every now and then you'll find a phenomenon of large number of CDs and DVDs being brought to a public place. They'll be made into a heap, like a small mountain, and they'll get an elephant to come and trample on the infringing copies. There's no legal requirement that you should get an elephant to do the job. You can as well get a JCB digger or some such excavator or something like that to do it. But they do it symbolically, and then they get the media to photograph this so that a message is sent out that video piracy or CD piracy will not be tolerated. And yet, of course, as soon as that happens, you can go to the nearby bazaar and buy as many infringed material as you want. So symbolism sometimes is just that. It doesn't actually result in any tangible action, any tangible difference. Now, I want to just look at a few cases. There's a case of GIAN and the Deluxe Films. This was about a movie called New Delhi. Now, this apparently was copied from a play called Hum Hindustani, but it was held by the court that there was no actionable infringement. There were similarities, but there was no actionable infringement because of substantial differences between the two. In other words, although one was sort of copied from the other, there were substantial differences which made the second different from the first. While the theme of provincial parochialism was common to both. In other words, now we go back to the first principle. The idea is common, but the form of expression is different. The play dealt with opposition to marriage between people from different parts of the country, and the film dealt, in addition, with the evils of the dowry system. In other words, there were some distinguishing features between the movie and the play, and in those circumstances, there was no copyright infringement. Then you have our old friend Anand Patwardhan featuring in another case. This had to do with a fight he had with Doordarshan. And what happened here was that there was a movie commissioned by Doordarshan, which is called 26 June 1975, which, as you can guess, was the date on which the emergency was declared. And this incorporated unauthorized footage from a film on the J.P. Narayan movement, which had been previously made by Anand Patwardhan, entitled Waves of Revolution. In other words, the Doordarshan movie copied something that had been included in Patwardhan's previous movie. And it was held that even the use of such footage was unintentional, because Doordarshan tried to argue that they didn't do it intentionally, it was completely accidental, etc., etc. The court said that it amounts to infringement of copyright, and it awarded damages of 1 million rupees, which I presume would be what, 10 lakhs, awarded damages and also a permanent injunction against further screening of the second film, I presume, until those scenes were removed. Barbara Taylor Bradford and Sahara Media Entertainment. This, I presume you know who is Barbara Taylor Bradford. Her allegation was that a teleserial called Karishma was an infringement of her book, A Woman of Substance. And after the producer of the serial reportedly said in a magazine interview that the general plot was based on the book. In other words, there was an acknowledgement that the general plot was based on the book, but probably a denial that the book was copied verbatim. And it was held that there was no ground for an injunction. In other words, Barbara Taylor Bradford tried to get an injunction. The injunction plea was rejected, which means the teleserial was allowed to go forward. And it appears that the case has been abandoned since. I think I saw an interview given by Bradford Rachel. It's not worth fighting this case in India, let's forget it. So there ended that case. Then you have a case which came from the Bombay High Court, which involved a concept note called Work in Progress for a teleserial. And the author of that concept note had submitted it to a TV channel called CNN IYER, and they then used it for their own program called Summer Showdown without any credit or payment being given to the author of the proposal. And here it was held that there was prima facie evidence of infringement. This happens a lot of the time. Suppose you are an author, you write a good story, and you submit it in the hope that it will be produced as a television serial. And the television channel accepts the note, makes a copy, and tells you, sorry, but this is not workable or whatever. Just shoos you away. But after a few months, you discover they made a television serial based on your concept note, without telling you, without paying you any money, without seeking your permission. And in those circumstances, if you can show that there's been infringement, then you will be entitled to damages. Many, many cases of this kind. It's ethically completely wrong, but there we are. Zee Films, same thing, movie called Kanaya, and again, there was a finding of infringement. Then there was a movie called Knockout. I don't know if any of you have seen it. Fairly recent, 2011, which apparently was based on a previous movie called Phone Book, and it was held as the original novel expression of an idea of a man held on stage with telephone book did amount to infringement. Again, it's a question of whether the similarities were such as to make a reasonable person see no difference between the later film and the previous one. There's yet another case of a concept note or a script being plagiarized. Again, nothing new. Now, there's one. You see, the Sony Corporation case is interesting for a different reason. And that is, movie producers. This is an American case. Filed a challenge to Sony because Sony had produced the first video recorder, which means that you can reproduce entire movies on a video, and you can watch and distribute the video if you wanted to. And they tried to argue that will entitle them to damages from Sony because they allowed for infringement. The allegation was not that they infringed it themselves, but they allowed for infringement and huge losses arising therefrom. The case was thrown out of court because it is a bit far-fetched. It's a bit like saying that because a lot of bank robberies take place using motor cars, therefore motor car manufacturers should be held liable for bank robberies. It's a bit far-fetched, and that was the argument which was rejected. But then the Sun case in the UK was interesting. What happened here was, the Sun is one of our cheeky tabloids, and what it did was, the Queen every year during Christmas broadcasts a message to the entire Commonwealth as the head of the Commonwealth, not as the Queen of England, but as the head of the Commonwealth. And that message is transmitted in all the Commonwealth countries by the national broadcasters. So what they used to do in the old days was they used to send videotapes of the recorded message days in advance to all the countries, and it was agreed that at a certain time on Christmas Day, the message will be broadcast everywhere. So there was an embargo. So you got your videotape in advance, but you could not telecast it till the embargo time. The Sun newspaper decided on one occasion to publish the content of the Queen's message in their newspaper before the embargo time. And that resulted in a case being brought by the palace against the Sun newspaper on grounds of copyright infringement, because what they did was breached the embargo and therefore breached copyright. And they won. The palace won, and the newspaper had to pay damages. So that's another example of how copyright law can be used in relation to embargoes. And then, of course, there's the issue of international works. Copyright Act extends protection to international works which are produced in countries that are parties to the Berne Convention on Copyright. I've already told you this. So, foreign works enjoy copyright in India and vice versa, as long as the country concerned is a member of the Berne Convention. And a majority of countries in the world are members of the Berne Convention. So that completes our look at copyright. Now what I want to do in the remaining time is go back to something I have not been able to do for the last couple of days, which is I want to complete our look at privacy and just deal. I was at this point when the lights went out 2 days ago, so I'll just complete that. And I promise you I'll today at 12:30. Okay, I won't keep you longer than that. Now, incidentally, before I start, a test of your general knowledge. There was something on privacy, an important development that occurred the day before yesterday. What is that? Internationally, not in Indian news, but something involving a celebrity. Not the Queen of England. Kate Middleton, the wife of Prince William. What happened was she was on holiday in France. She was sunbathing in a private estate, and a photographer for a French magazine took pictures of her from a very long distance, I think 2 miles, and published those pictures in a French magazine called Closet. And the princess, or the duchess as she is now, sued that magazine, and the French court gave judgment in favor of the duchess, and damages were awarded. So that is an example of how even celebrities sometimes can sue and win in relation to privacy claims. Okay, now let's come to the Max Mosley case, where this man, I told you he is the owner of Formula One. What he did was he held a party on the day of his own birthday. He gave a treat to himself, but it was a rather odd party. He brought together a group of what subsequently turned out or was revealed as a group of prostitutes who were to engage in a sadomasochistic session. That was the treat he gave himself in a private room, on private premises. Now, one of our tabloid newspapers knew about this in advance, paid some money to one of the participants in that party, which actually was, as the newspaper called, an orgy rather than a party. Anyway, they paid money. So this lady had a secret camera attached to her body, where she filmed what was going on. And there was the usual stuff that you would expect in a party like this, except that the images seem to indicate that there was a Nazi theme to the party, that the clothes that the participants were wearing resembled that of Nazi soldiers. Now remember that Max Mosley already came with some Nazi baggage, in the sense that his father was the fascist leader in England, Oswald Mosley. So what the newspaper did was give a title, which was "Sick Nazi Orgy," to the item, and produced pictures from the inside of the party. Mr. Mosley sued. He did not sue for defamation because he knew that the material was substantially true. But he said that there was no justification for the publication of the story and the pictures, because at the end of the day, that was a private party and they had every business to keep information private. The newspaper argued that there was a public interest in it because at the end of the day it was a public figure, and secondly also that because of this Nazi theme, it deserved to be exposed. Except that the newspaper was not able to prove that there was actually any reference to Nazism at all. So for that reason, of course, the newspaper lost, and Mr. Mosley won. He was paid £60,000 for budget damages for breach of privacy. Now, what the court said was that there was an obligation of confidence even in relation to paid sexual activity, and it is not. And the lady who revealed this information should not have revealed it. Breach of confidence. We go back to the principle I mentioned earlier. And there's a right of every person, including those engaging in unconventional sexual behavior, as Mr. Mosley did, to privacy. So even if you do something unconventional, you are entitled to privacy. And here there was no issue of being a role model or anything, the way that the Naomi Campbell case happened, or the Tixton case happened. And weight should be accorded to a journalist's sincere view that the party in question was one involving Nazi theme, but they could not prove it, and therefore they lost. But the editor of the publication removed the creeping law of privacy emanating from Europe. The result of this case was largely determined on the fact that there is a strong privacy protection with the European Convention on Human Rights, and the editor therefore complained about that becoming, or that overshadowing English law. And he argued that the paper had an honest belief that Nazi theme was involved during the orgy, except that they could not prove it to the extent to which the law required them to prove it. Yeah.
So though we have said, sir, that public figures are not protected, but in case of yes, they should enjoy privacy. But what happens when a public figure found in some kind of a behavior which is slightly not normal, or not in conformity with his standard personal life?
Well,
Pictures are being published.
there are two things here. One is there was no allegation of hypocrisy because Mr. Mosley had never ever made any statements about the need for clean parties or anything like that. Secondly, this is a very private party which he took great precautions to keep private. There was no possibility unless inside the room and got someone to take photographs of the material coming out. It's not like him being pictured on a public street or anything like that. So for all those reasons, the court held that here, freedom of expression did not extend to covering something as private as that. There are other laws to protect privacy. I've already told you anti-harassment laws, some of which are not available in India. Data protection laws not available in India yet. Anti-trespass laws available in India but not used a lot of the time. Laws against appropriation of personality. This is interesting. I have told you that it is not a violation of Indian law to take a picture of someone in a public place and publish that picture. Now some people will feel aggrieved about that, as did Mr. Ansari. I don't know if you remember. Does anybody remember Mr. Ansari?
Gujarat riots.
Correct. I've got a picture of that. This is what caused the problem. Remember this picture, which appeared so many times. Mr. Ansari at one point got extremely cheesed off, extremely upset. He said, look, for God's sake, will somebody do something to stop that picture being published? Because I feel so affected by it. Sadly, nothing could be done, because there is no law in India against appropriation of personality. Then of course in copyright law, there is a case which involved Prince Charles. What had happened was, Prince Charles had written a private diary after he had attended the handover of Hong Kong to China in 1997. And in his private diary, which is circulated to a few of his friends, he made some very frank remarks, frank and unflattering remarks about Chinese leaders, including calling them waxworks, etc. Now, somebody leaked a copy of the diary to one of our newspapers, and the newspaper published extracts. Prince Charles sued on the grounds that copyright law had been violated, because he couldn't sue on any of the other legal grounds, and he won because the newspaper did not have permission to reproduce copyrighted works, and Prince Charles had copyright in the diary that he had written. So that's an example of how you can sometimes use copyright law to protect your privacy. Do journalists have a right to interview people in prison? What's your answer? Yes or no? I'll give you an example. You know that Ajmal Prasad was lodged in Arthur Road Jail in Bombay. Could you as a journalist insist on the right to interview Ajmal Prasad? No? Yes or no?
No.
Not at all.
With his consent.
With his consent. Yeah? Okay. That's half the answer. There's another half to be given. What is that?
With the consent of the jail authorities.
Correct. So you need the consent not only of the prisoner but also of the authorities. Okay? And you have a few cases there which involve precisely that. I would say, generally speaking, the law in India is liberal enough to allow for interviewing prisoners as long as the prisoner consented. And if the jail authorities unreasonably refuse permission, I would say that you can go to court, and there's a fair chance that the court might, having regard to the facts, allow you permission to interview.
Sir, the Indian Home Ministry had made it very difficult now to do this after this. BBC had done a documentary, I think BBC on this Ashwara case.
Yeah.
With a lot of restrictions. It's almost impossible for a journalist to interview this.
Okay.
Yes, and in some cases it is subject to their clearance. I mean, after the interview, the jailer might like to see the text of the interview.
But that is a matter of negotiation and agreement. If you as a producer say, sorry, I won't show it to you, you may not get the interview, but they can't compel you to show, to carry out the interview and then show it to them. So that's a matter of negotiation and agreement. It's possible that depending on the bargaining power, sometimes the government may be keen for a foreigner to do a movie because they think it will give them some brownie points. It depends on the situation. But the short answer to the question is, you need the permission of the prisoner, you need the permission of the authorities. Okay, that brings us to the end, essentially, of our look at privacy, and that brings us neatly to 12:30. So, for once, we are able to conclude on time. Tomorrow is the last day. Can I beg of you, I'm using a different word now, please turn up on time, okay? Because tomorrow is an opportunity for you to ask any questions you might have to ask on anything that we have dealt with so far, okay? So let's leave a little bit of room tomorrow for all that. There's, of course, a substantial topic to be addressed as well. Okay, thank you.
Just